Hello, this is part 7 of handling your car accident case without a lawyer, without going to court. And in this video, we're going to be talking about writing the demand letter. This is the letter that you write to the insurance company demanding that they pay you a certain amount. And I'm going to be talking about when to send a demand letter, how to organize the evidence for it, some basics for the demand letter, and the amount to demand. Again, this is a disclaimer here that I'm not giving you specific legal advice. You're not a client by watching these videos. And this is more of a general guide for people who want to handle the case on their own without a lawyer and see how if they can get a good result or not. I'm talking about California law. The law changes from state to state, so you should be aware of that. And I'm talking about this video was made in 2020, and the laws change year to year, so you want to make sure you're up to date and aware of all of that. Who am I? My name is Jonathan Howell. I'm an attorney in Los Angeles. I handle cases all over California and have handled injury cases for years. And so sometimes there's cases that you can handle without an attorney, and that's what I'm assisting or making these videos for now. When to send a demand letter. The time to send a demand letter is really when you've got a good handle on your injury. It's either the treatment is plateaued or you know what's in store for the future. You want to make sure you have all the evidence for the case. So you want to make sure you have the police report, if it's applicable, photographs, witness statements, everything is nailed down. You want to make sure that you've got your medical records and your bills for all your providers. You want to make sure you understand how much insurance paid, health insurance paid, if any. You want to make sure that you're not in the middle of treatment or still experiencing pain and it hasn't been fully diagnosed yet, because you don't want to leave something out in the demand. You want to make sure you have the employment record showing your loss of income, if that's applicable. And you also want to have a good understanding of the availability of insurance at this time. So you want to have a good understanding of the person that caused the crash, their insurance limits, and maybe you've already reached out to an adjuster to have them open a claim, and what your insurance limits are. How much medical pay, which is the amount of insurance you have to just pay medical bills, a certain type of coverage for that. So you want to have a good understanding of all these things and have the evidence organized before you send the demand letter. When you send a demand letter, and usually one of the first things I do before I even start writing the letter is organize everything. Organize the medical records so you know exactly what you have and when the date ranges. And earlier in the other video, I talked about redacting. This is probably a good time to redact anything that's fully unrelated, or like your social security number, things like that. You want to make sure you have all the bills. And oftentimes I like to have, even along with the bills, a summary of the bills, so that the adjuster doesn't necessarily have to go through all the bills and figure out what the total is and how much was paid and by who. You can put that in a summary. Same thing with the medical records. You can summarize those, and you don't have to do an overly detailed summary. You can do a summary with just date, provider, and the extent of treatment, and do a couple lines so that it's someone can see a timeline of the treatment you got. I try to have everything in a PDF format so I can email it, or it just makes it easier to work with in a PDF format. Same thing, you want to have photos ready to go and organized and named properly so you can see photographs of the property damage, etc. When you're actually writing the demand letter, usually what I like to do is, you write the letter, you want to put the claim number information in the letter up front in the RE section, regarding section, because that's where the insurance company knows where the letter is supposed to be routed in case you have the wrong adjuster. You want to make sure it's addressed properly to the correct adjuster, correct insurance company. Your client's name is in there, the defendant's name is in there. And if you want a format or a sample format for that, just go to our website, send us a message, howelljustice.com, send us a message and we'll send you over a sample demand so you can see what that looks like. Typically, you want to start with the amount that you're demanding and the deadline to respond. You usually want that right away in the first paragraph of the letter so they know what's happening, that you're demanding money, and how much time they have to respond. Some attorneys, they vary in the amount they give to respond. Usually In an initial demand, I'll give anywhere between 2 weeks and a month for them to review the demand. You don't want to make it too short, especially if there's a lot of medical records, and they're dealing with other stuff and they're looking at other records. On the other hand, you don't want to make it too long either, and oftentimes they'll call you up and ask for more time. And maybe I'll give them one extension up to another 2 weeks or 30 days, but not more than that, because they will try to extend and extend as long as they can. That's one of the things insurance companies love to do, is they love to delay. In the demand letter, I put in the facts, a summary of the facts, and try not to make it overly blown, dramatic. You just want to state the date, the time, the location, who was involved. There was a severe impact, the type of crash. Was it a rear end, T-bone? A little bit about what happened. Did they run a stop sign? Something like that. And you want to put a little bit of information, try to be objective about it, and a little information about what happened afterwards, if they said anything to you, if the police came, if you left the scene in an ambulance, etc. After that, I summarized the treatment that was received, maybe a little discussion of why the person that hit you is at fault. So before that, I'll even do that, where I'll say something like, it was a rear end accident, very clear liability. I'll put in a separate section where I summarize the treatment, beginning with the first treatment and then to the present day, and then a discussion of what's in store for the future. I put in a little summary or discussion regarding the bills. Same thing, another discussion, lost wages, and then a pain and suffering discussion. All of these have headers. This is typically what I do, so that they can skip around the letter and look for the section go to the section that they're looking for. Because adjusters will take your letter and they'll go to their supervisor and they'll round table it, and you want them to be able to navigate your letter quickly and easily to find the sections that they're talking about. For pain and suffering, you want to maybe pick 3 to 5 ways in which the crash has affected your life in a more subjective way, like if it's affected your sleeping, if it's affected your ability to do certain hobbies or activities that you used to do that you really like doing, cooking, exercising, whatever it is. You want to discuss that there. And then you have a conclusion, and that's usually where I'll put I'll restate the demand amount and the deadline, and maybe say a few lines about why they need to act promptly on it. In terms of style and tone, I try to keep the letters very efficient and also not overly dramatic. I try to keep it very dry, just stating the facts, because I find that the adjusters, it doesn't really work if you put too much anger in there. If you're very upset, or if you put in a lot of threats to the insurance company, they're probably not going to respond, but that's probably not going to help. But if you keep it very objective, and it's almost like you're helping them do their job, helping the adjuster do their job of understanding what you went through in a nice, clean fashion, so that when they can go and present that to their supervisor and get some authority to settle your case. In terms of what's the amount to demand, that's a very complicated question. And oftentimes I look to the extent of the injury. I look at, if there's any issues with liability, I look at insurance, and I made a list here of all the different things that I look at. Insurance availability is very important. If the person that hit you only has $15,000 of insurance and you don't have any other insurance and there's no other source of recovery, well, then you're capped at $15,000 basically, unless you can really think that the other person should have to pay personally. And there's some rare circumstances where that may be, but realistically, it sounds like you'd be capped at $15,000. You need to know that going into the negotiation, because at that point, maybe it doesn't make any sense to demand $30,000, no matter what your injury is, no matter what your bills are. Another factor in determining the amount is the bills. Obviously, you want to request enough money to cover your bills plus the pain and suffering that you went through. You don't want to request or start demanding money that's less than the bills. You want to make sure you've covered all your losses. If you lost like other property damage that wasn't covered, things like that. You want to make sure you cover the cost of future medical expenses. And you want to make sure that whatever medical doctor you saw discussed those medical expenses and put them in a report so you can cite that. So hopefully the doctor said that you're now a candidate for pain management treatment at $5,000, something like that. And now you can save $5,000. You want to talk about future lost wages. So if you are now disabled or expecting to lose time from work, realistically, a case like that, you should probably be hiring a lawyer if you're talking about future medical expenses and future lost wages, because it's getting complicated and you don't want to blow it. But those are things that you're thinking about. Future lost wages, you want to make sure that you include that and have a reason why you're going to lose those wages in the future. It can't just be you just say it. It has to be connected to a medical reason or some good reason. In terms of pain and suffering, past and future, you're entitled to that. And if you go to jury instructions and you type in jury instructions, pain and suffering, they'll tell you a little more about the different categories, loss of enjoyment of life, disfigurement, things like that, that play into that. And that's, really one of the most difficult things to value. But you can kind of Google around what jury verdicts are, and just type in your jurisdiction or wherever you are, your city and state, type in jury verdict, whiplash, type in the injury and see what verdicts come back. And that's one way you can do it. You can often also sometimes call an attorney and try to get a consultation and see what they think the case is worth. But that's one of the hard things about evaluating the case. You should know that small claims court, for example, in California, for an auto case, I believe it's $7,500. For other cases, it's $10,000 is the limit. And so, or if you have insurance of only $15,000, maybe your goal really isn't to try to evaluate the case perfectly, but to get the maximum amount that you can from insurance, or the equivalent of if you had gone through small claims court, gone through that process. So that's the discussion on the demand letters. If you want a sample or have any questions or want some more free resources, go to howelljustice.com, drop us a note, and we could answer any of your questions.